we set out to prove that gay and lesbian citizens are like everyone else in this country. They're entitled to pursuit of life, liberty, and happiness. Marriage is a fundamental right, described by the Supreme Court 14 times as fundamental to our existence, to a part of freedom of association, liberty, spirituality. It is a building block of our society. We respect people who wish to get married, to love one another. When California and other states have denied the right of gay and lesbian citizens to get married, they've denied that fundamental right of happiness. Individuals whose sexual orientation would not put them in a happy relationship with a person of the opposite sex. It does no harm to heterosexual couples or the institution of marriage or the raising of children to allow gay and lesbian citizens to get married. So it's a discrimination against them because of who they are. And when a state like California puts it in the Constitution that individual relationships between gay and lesbian citizens aren't as well respected, that's the state of California saying you can discriminate. These people are different, and it brings about all kinds of discrimination against gay and lesbian citizens, because we're telling young people, well, their relationships, something's wrong with them. They're different, they're unusual, they're to be less respected. So the great damage is done, and it's just plain wrong under our Constitution to put these citizens in a separate category and deny them equality.
Is it a 14th Amendment then, equal protection?
Yes.
Is that the basis
Yes,
of the argument?
the 14th Amendment to our Constitution guarantees everyone the right to due process, which means you have a right to fundamental rights in this country, and the right to equal protection under the laws. That's the right to protection of equal laws. And we were making the argument under both the due process clause that marriage is a fundamental right that can't be taken away, and marriage is a right that can't be taken away because of who you are. That's the violation of the Equal Protection Clause.
Yeah, what did you think, Mr. Boies, when Mr. Olson got that question from Justice Scalia? Since when did it become unconstitutional to not allow gay marriage? What went through your mind?
Well, I thought his response was the right response, which is really a rhetorical question. When did it become unconstitutional to prohibit people of different races from getting married? When did it become unconstitutional to segregate schools? Because what you have is a development of the law in which we, as Justice Kennedy has said so eloquently, each generation discovers that some of the things that we thought were sensible and right really serve only to harm and discriminate. And I think that when you see the progress of that law, what you see is the country coming closer and closer to what the fundamental ideals were of our founding fathers, because they were all fathers in those days. And when they talked about life, liberty, and the pursuit of happiness, when they talked about equal rights, when the Constitution begins, we the people of the United States. In those days, we the people were essentially white male property owners. And what's happened is, over time, who the we is in we the people has gradually expanded until, as Ted was saying, really the last official bastion of discrimination is the discrimination that our government practices against people based on their sexual orientation. We've got a lot of discrimination in our society, but this is an area, unlike other areas, where the government still discriminates against its own citizens. And I think it's important to keep in mind that the right to marriage equality is not a new right. Nobody is creating a new right out of the Constitution. The constitutional right to marry the person that you love has been recognized over and over again by the Supreme Court. The state of Wisconsin passed a law that said if you've abused one marriage, you don't get a second marriage license. If you aren't paying your child support or you abuse your spouse, you can't get a marriage license a second time. Supreme Court said that's rational, that's sensible. But you can't do it. And the reason you can't do it is because marriage is such a fundamental right that you can't deprive people of that, even when they have engaged in that kind of conduct. And compare that to gay and lesbian couples who have only behaved in a normal way, only want to be with the person that they love. How could you possibly deprive them of the right that the Supreme Court says constitutionally is given to everybody else, even people who have abused that right in the past?
You mentioned Wisconsin, and that actually raises another constitutional question. Since we're looking at this in the, with the overall framework of the Constitution, Mr. Olson talked about the 14th Amendment, equal protection. Is there a 10th Amendment states' rights issue here? What do you think, Mr. Boyce?
Well, there are certainly 10th Amendment states' rights, but the 14th Amendment was designed to say there are certain rights that states don't have. The whole purpose of the 13th, 14th, and 15th Amendments was to say there are certain states' rights that we're going to take away. We're going to take away a state's right to discriminate against its citizens. We're going to take away the right of a state to deprive its citizens of due process of law, because we think fundamentally in one nation indivisible, there are certain rights that are so fundamental that everybody gets to enjoy them, no matter whether you live in New Hampshire or Texas or California or someplace in between. And there are certain rights that can't be taken away from you by any majority. Not a 52% majority like Proposition 8 had, not a 98% majority, because there are certain rights that everyone has that are so fundamental that they are guaranteed to everyone, whether or not the majority at a particular time agrees with it.
I'd love your thoughts on this too, Mr. Olson, this idea that the 14th guarantees certain rights to everyone, no matter where they live. Marriage has always been a states' amendment, a states' rights issue, so you've kind of got the 10th and the 14th working at cross purposes here.
No, I
Correct
don't
me if
think
I'm
so.
wrong.
I don't think so. The 10th Amendment, for those who haven't spent their time reading the 10th Amendment, the 9th and 10th and 11th and 12th Amendments don't get much attention, even in law school. The 10th Amendment a little bit more. The 10th Amendment reserves to the states the rights that are not otherwise taken away and given to the federal government and supplied by the federal government, or reserved to the people in the Bill of Rights, the right to free speech and that sort of thing. So it's a reservation of rights to the states that are to the states of rights that are not otherwise described in the Constitution in one way or another. And the states have always claimed, when there's been resistance to civil rights, if those of you who are old enough to remember the 50s and 60s when we were having battles over discrimination, David, by the way, was in Mississippi fighting for those rights. People who wanted to keep discrimination on the basis of a race, we're talking about states' rights. And we were talking about states' rights at the time of the Civil War, the rights of states to have slaves, to allow their citizens to have slaves. The 14th Amendment specifically says that all citizens, no state may deprive any person of due process of the law or the protection of equal laws or the equal protection of the laws. So the 14th Amendment is an explicit override, so to speak, of the 10th Amendment. Some arguments are being made about states get to do this sort of thing and that sort of thing. But no, and as David puts it, the reason we have an independent, aggressive judiciary to protect those rights because we don't put certain things up to a vote, and states just cannot do that sort of thing. The Supreme Court dealt with this issue when in 1967 the state of Virginia, my home state now, I grew up in California, but I live in Virginia now, Virginia and 15 or 16 other states prohibited interracial marriages. And the Supreme Court unanimously struck down the provision in the Virginia's laws that made it a felony if you were to marry someone of a different race. The president, when he was born, if his parents had tried to get married in Virginia, they would have been committing a felony under this kind of law. So the Supreme Court brushed that away and says, no, it's not a matter of states' rights. It's a matter of fundamental Constitution, individual rights. The other thing, one of our opponents during the course of the Proposition 8 case talked about, well, states have the right to restrict marriage because the states have, and this was hard to explain, but they have an interest in encouraging responsible procreation. And we 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 went around and round with them because the interest or ability to procreate has never been a condition of marriage. People that are past the age of procreation, or people who are unable to conceive, or people who have no interest in conceiving, are allowed to get married. People in prison are allowed to get married. People who are on death row are allowed to get married. So procreation is not it. Procreation is certainly part of marriage in many cases. But we pointed out in the case, this isn't the right of the state. This is the right of individuals. If you think of it as the right of the state to advance procreation, even if you could make sense of that argument, it isn't the right of the state. Because if the state had the right to allow people to get married because of procreation, if the state, like China, decided we want to reduce procreation, then the state could take away the right to get married because it would somehow, theoretically, reduce procreation. Some of you know that's not going to work. But the point is, and we kept trying to make the point, this is not the right of the state. If you reverse it, in many countries of the world, the state gives you rights. This Constitution was created by the people that gave limited power to the government. Everything else belonged to the people. The government doesn't have any rights unless we give the rights to the government to restrict, to regulate commerce, or do things like that. But we start with the rights belong to the people. The rights don't belong to the states. And I think that's so fundamental. We tried to make that point in our briefs and every time we talk about this. We're talking about human beings and the rights that we have. The Declaration of Independence, these are inalienable rights. We are endowed by our Creator with those inalienable rights.
I want to ask both of you about something else that came up before the court. Justice Alito raised another issue that often comes up in these big, groundbreaking cases, and it certainly came up in this case. Alito urged caution. He raised this idea that I'm sure both of you are familiar with, the court, quote unquote, getting ahead of the public. You want us to step in, he said, and render a decision based on the effects of this institution, which is newer than cell phones or the internet, another quote that got a lot of play. He said, we do not have the ability to see the future. What do you think about this? I'll go to you first, Mr. Boyce, but I'm guessing you both have lots to say about it.
Sure.
This idea that you two are pushing the court and the country in a direction that perhaps it's not ready to go.
Well, remember, we didn't necessarily push the court to take this case.
They agreed to take it.
True enough. Yes. We were perfectly happy with the Federal Court of Appeals decision that was in our favor. So if they had wanted to wait a little while before wading into these waters, that would have been fine with us. I think that inevitably the court has to lead. I think the court has always been at its best when it has led, as it did in 1967 when it said to Virginia, no, you cannot put people in jail because they marry somebody of a different race, or when they said in Brown against Board of Education almost 15 years earlier, no, Kansas, you can't tell students to go to school in separate schools just because of their race. Or when the court has said that anybody who is arrested by the police has certain basic rights, and those rights have got to be respected, whether you believe they are guilty or whether you believe they're innocent. I think the court has also been at its best when it's recognized the mistakes it's made. I think the court has recognized that cases like the Dred Scott case, in which the court approved slavery, or Plessy v. Ferguson, where it approved segregation, or the Japanese internment cases, where they approved rounding up American citizens who had engaged in no improper act simply because of ancestry. The court has said in subsequent cases, with respect to each one of those cases, that's wrong. And I think that's a strength of the court. I think the confidence of the court to be able to recognize when it is wrong and when it has failed to lead. The Constitution was designed to make the court lead, because if you only go by the majority rule, you don't need a written Constitution of rights. You don't need a Bill of Rights if you're just going to allow the legislature to decide every time, are we going to have freedom of speech? Are we going to have freedom of press? Are we going to have freedom of religion? Are we going to allow people to be incarcerated without a jury trial? Are we going to allow we allow states to limit who can get married? So every time the court steps in a constitutional case like that, it is stepping in because it has to lead. It has to say, no, the Constitution says something different than what this temporary majority, either in the national legislature or state legislature, believes. So I think that's inherent in our Constitution, certainly since Marbury against Madison, where the Supreme Court recognized that it had to be the final arbiter of the Constitution. The court has been in a position where it is inevitably had to lead. Now, the court never wants to get, maybe from a public relations standpoint, too far out front. It's subject to criticism when it does. But I think it's also subject to criticism when it doesn't. And I think that if you look at the great justices of the court and the great judicial opinions, they are opinions and justices who rose to the occasion and expanded human rights, expanded civil rights, not the ones that curtailed them or held them back.
That's interesting. Mr. Olson,
Well,
what do
I
you
can't
think? Yeah.
answer it better than David, but it came up in the trial court, too, the trial court. And the courts raised this question, and I can't read Justice Alito's mind with respect to why that question was raised, but the courts are concerned that people understand that they have to make these decisions sometimes, despite the will of the people or a majority vote. And the answer really is, that's your job. Minorities don't win elections. The unpopular people or unpopular people that look different or think differently don't win elections. The majority wins elections, and those are the, you know, we have courts because we don't turn this over to George Gallup. And I basically said in the politest way I could to the trial judge, that's your job. That's why you are there. That's why we have judges. That's why we have an independent judiciary. Because if you just put things up to a vote, unpopular people or unpopular ideas will lose. And it's particularly true in the First Amendment area. People who express unpopular ideas or won't take a loyalty oath or do that sort of thing. The Supreme Court decided just a case a year or so ago about some people that were saying vile things at funeral, and the same people are going to be back in the Supreme Court, I think, next year, but they're saying vile things at funerals of our soldiers. The Supreme Court said, well, you know, we let people say those things because of the First Amendment. But that is an instinct that people have. The first time I told my mother about this case, she said, well, what about the people who voted for Proposition 8 in California? And I explained to her, and she's pretty smart, she picked it up, and but that's the natural instinct. I mean, are we taking away things of the people? It's very important that people get to vote. But that's why we have three branches of government. That's why we, as David says, we have a constitution, and that is your job. You know, that's why you have life tenure. You get to make unpopular decisions, and they can't take you off that bench.
Do you think people appreciate that, Mr. Boyce? The idea that if we didn't have a court system, you know, there is the idea that majority should rule, people win elections, but, you know, he made a compelling case, and so did you, that if we didn't have courts, we would be sort of run by, with all due respect, Mr. Gallup. Do you think people understand / appreciate that?
I think people appreciate it to some extent. I think everybody appreciates it more when you are the object of the discrimination. I think that...
Or when they rule in your favor.
You know, I think that when you have people who are not subject to discrimination or don't think they will be, I think it's easy to be a little complacent and not appreciate the role of the courts. But I think even people who are fortunate and are the least likely to be the subject of discrimination and constitutional violations know that if we're going to have the kind of society that we all want to have, we're going to have to respect the rights of other people and not just our own rights. We're going to have to find a way to work together. We're going to have to find a way in which, even when we disagree, we respect the rights of people to disagree with us under the First Amendment. Even if you are a person who has a sincere religious belief that says marriage and sexual relations should be limited to people of opposite sexes. And a number of people in this country have a sincere religious belief about that. They're entitled to that belief, but they've got to recognize that the First Amendment that guarantees them that right of free exercise also prohibits an establishment of religion and prohibits anyone imposing their religious beliefs on somebody else. One of the things that happened in Proposition 8 is you had churches on both sides arguing their vision of what their religion taught. And the basic premise of the Constitution is the state's got to stay neutral. The state stays out of the business of deciding which religion, what religious tenets succeed and what don't.